Teen Sexting Defenses to Criminal Charges in New York and New York City by attorney Andrew M. Stengel. Teen sexting charges have serious consequences in New York. A teen sexting conviction results in a permanent felony criminal record and requires a registration as a sex offender. However, teen sexting diversion, if a person is eligible, does not result in a criminal record. New York has important defenses to teen sexting charges when there is a mistaken belief that a person is not a minor. A minor who falsely claims to be at least 17 or 18 years old may establish a defense to teen sexting charges. There are two important teen sexting defenses when a minor falsely claims to be of legal age. First, the absolute defense of a reasonable effort to ascertain the true age of the minor who turns out to be less than 17 applies to the crime of disseminating indecent material to minors in the first degree. Second, the affirmative defense of a good faith reasonable belief that a person was either older than 16 or 17, depending on the charge, applies to the crimes of possessing or promoting a sexual performance by a child. For an absolute defense, the burden of proof is on the prosecution to prove beyond a reasonable doubt that a person did not make a reasonable effort to learn the age of a person who turns out to be a minor. For an affirmative defense, the burden of proof is on the accused to show proof that there was a good faith reasonable belief that a person was not a minor, but by a lower standard of preponderance of the evidence. Disseminating indecent material to minors in the first degree involves allegations of an electronic communication with a minor who is less than 17 that depicts or describes actual or simulated nudity or sexual conduct, combined with an invitation for sexual conduct or to create a sexual performance. The defense of a reasonable effort to ascertain the true age of the minor applies to the crime of disseminating indecent material to minors in the first degree. Under New York law, it is a defense to the crime that a person made a reasonable effort to ascertain the true age of the minor and was unable to do so because of actions taken by the minor. Possessing a sexual performance by a child is charged when, knowing the character and content thereof, a person knowingly has in his or her possession or control, or knowingly accesses, with intent to view, any performance that includes sexual conduct by a minor who is less than 16. Promoting a sexual performance by a child is charged when a person allegedly produces, directs, or promotes any performance that includes sexual conduct by a minor who is less than 17. In New York, it is an affirmative defense to both crimes that a person in good faith reasonably believed that the minor appearing in the performance was at least 16 or 17, depending on the charge. Whether or not a person can establish a defense when a person turns out to be a minor depends on the facts that are unique to every case. If two people connected over a dating app like Tinder or Grindr, then there's already a reasonable belief that a person is at least 18 because of the app's minimum user age and the age posted on a user's profile. Connections made over social media apps like Instagram, TikTok, and Snapchat are riskier because of a lower user age requirement, and ages are not typically posted on a user's profile. A minor who lies about their age by showing or sending a phony photo ID can help establish a defense to teen sexting charges. Former New York prosecutor Andrew M. Stengel is an experienced and knowledgeable teen sexting and revenge porn lawyer. Andrew M. Stengel is a skilled trial attorney, a diligent investigator, and a tenacious representative. Whether the case involves an allegation of teen sexting, revenge porn, or any other criminal charge or investigation, Andrew M. Stengel provides skilled and vigorous legal advice and representation. For more information, visit the website of Andrew M. Stengel, www.stengellaw.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.